morning. Thank you. Thank you, Jeff, and thank you, Courtney. I appreciate the opportunity to present this course. Um, as I mentioned, I am a Florida Bar Board Certified Condominium Specialist in Plan Unit Development Law, which is a mouthful. Our firm does have several of those. I think we have 8 or 9. So we have a lot of board certified condominium PUD, Plan Unit Development attorneys. What we do here at Kaye Bender Rembaum is we represent associations. That is our principal business. I would say it's 99% of what we do. And we represent thousands of associations throughout, well, over 1,000 throughout South Florida and up into mid-Florida and on the West Coast. Personally, just a little bit of background on me. I've been practicing law for 41 years, entering my 42nd year. So I've been doing it for a little bit. In a prior life, I used to represent developers where I drafted condominium and HOA documents. That was actually done in the Washington, D.C. area and in Maryland. But for most of my career, I've been representing associations in South Florida, Dade, Miami-Dade, Broward, Palm Beach, and other counties. So that's enough about me. You didn't come on to hear about me today. So without further ado, as they say, we're going to start this course. And as Jeff really hammered home, and Courtney as well, this is a homeowner association board member certification course. Not condominium, no co-op, it is HOA. So that's me. You don't have to see me anymore.
And Peter, I just want to mention, this came up twice in the Q&A already. Folks, the link you used when you registered is associated with the link you got after registering. Clicking on that link is the same as signing in. So you don't need to ask me, can you see me? Am I here properly? You're good to go. Peter, back to you.
Yeah, don't ask me any technical questions.
I'll handle
we'll end up deleting the entire thing. All right, so why are we here? Okay, we're here because you want to be here, hopefully. You're here because you're going to get known as, you're going to be certified. So what does that mean? Under the law, within 90 days of being elected or appointed to the board of an HOA, that newly elected board member must complete the education curriculum administered by an education provider approved by the Department of Business and Professional Regulation, someone like myself. Okay. Now, the certificate of completion that you'll receive today is valid for up to 4 years, and a director must complete this education specific to newly elected directors at least every 4 years. So it's an every 4-year thing. For those of you who are wondering who have been on the board for a while, it used to be you had a choice. You could take a course from a certified provider, or you could sign a document saying you've read the document, you'll uphold the documents to the best of your ability, blah, blah, blah. That is no longer, that's no longer good or valid to be certified. Now you actually must take the course. Interestingly, for condominiums, they have to take a course and sign that document. Why is it different for HOAs and condos? Who knows? That's what the legislature decided. So you have to take this course. It's good for 4 years. The course includes information and training regarding financial literacy and transparency, record keeping, levying of fines, notice and meeting requirements, and other things. Okay. If you do not become timely certified, you're suspended from the board. You're not removed permanently, but you're suspended until you comply with the education requirement. During that period, the board can temporarily fill the vacancy. The association must retain each director's educational certificate for inspection by members who want to see them for 5 years after the director's election. However, the failure to have the certification on file with the association does not affect the validity of any board action. So if there's an oops, and oopses do happen, where the certificate is not on file, it doesn't discredit or invalidate any board action during that period. Now, in addition to becoming certified, there is a continuing legal education requirement. So a director of an association that has fewer than 2,500 parcels or lots, the HOA Act refers to it as parcels, but you and I typically call them lots. That director has to complete at least 4 hours of continuing education annually. A director of an association of less or 2,500 parcels or more has to do 8 hours. So if you're fewer than 2,500 parcels, it's 4 years of continuing education a year. If it's 2,500 or more, it's 8 hours. Chapter 720, we're going to go into that now. By the way, Chapter 720 is the Florida Homeowners Association Act, not to be confused with Chapter 718. That's the Condominium Act. So what's the difference between an HOA and a condo? Okay, one might say, well, one's tall and one's short. Well, that's not necessarily true. Okay, an HOA exists with or without enabling legislation. For example, HOAs have been around for years and years and years and years without any statute governing them. That didn't really come into being until the 90s. Okay, it is a creature of common law. In an HOA, the association will own the common area. All right. On the other hand, a condominium is a creature of statute. There is no condominium unless there's a statute enabling it. And here in Florida, that's 718. It used to be Chapter 711, but that was amended 718 many years ago. Unlike common area, condominiums have common elements. Unlike common area, the common elements are actually owned by all the owners in undivided shares. And there's differences regarding alterations to the property, but we'll talk about that as we go along today. So what law applies, or what version of Chapter 720 applies? Long story short, basically the law applies as it existed when the Declaration of Covenants was recorded, okay? However, there is something called Kaufman language, which many of you may have heard of, okay? Kaufman language goes back to a condominium case dealing with rec leases. It's a case called Kaufman versus Shear. Long story short, in that case, that declaration of condominium was subjected to the Condominium Act as amended from time to time. Because it had that language, then the court held that future amendments to the Condominium Act applied substantively to that declaration. So with regard to HOAs, your statute, as I mentioned, is Chapter 720. The version of Chapter 720 will apply to an association at the time it was created, unless it has that Kaufman language, except, and there's always exceptions, right? Make your life miserable. Makes my life difficult too. Procedural matters typically will apply, okay, retroactively to an existing declaration, whereas substantive changes in the law generally will not apply retroactively to an existing declaration unless that declaration adopts future amendments to Chapter 720 within it. Now, this is a very detailed topic. I can probably go on for a long time about it, but again, this is a overview course, so I can't. So procedural laws means procedural matters are things like meeting notices, stuff that operates the procedure of the association. Substantive are more of your vested legal rights and duties. And those things are more, again, they're substantive as opposed to procedural. I know that's kind of a brief description, but just think about one is the operational aspects, like the time to provide notice, the time to post notice, things like that, as opposed to your substantive rights of use of the property. Now, most, if not every association is also created pursuant to Chapter 617. Chapter 617 is the Florida Corporation Not-for-Profit Act. Okay, so basically an association will be subject to both. It'll be subject to 617, which is the Not-for-Profit Corporation Act, and Chapter 720. Now, as I mentioned before, Chapter 718 deals with condominiums, 719 deals with co-ops, 721 is timeshares, and 723 mobile homes. The specific provisions of Chapter 720 will control over Chapter 617. If it's silent, in other words, if 720 doesn't address an issue, then you may have to look at Chapter 617 for that particular issue, as again, because the association is subject to both laws. Now, conflicts. Little dabble do you? Anyone recognize this ad from Brill Cream from like 1950, whatever? I'm old, not quite that old, but I do remember the Brill Cream ads. This deals with, or this slide is dealing with what happens or what is the impact of a conflict between your documents. And you are governed by a Declaration of Covenants, Articles of Incorporation, and bylaws. And actually, there's a fourth one not mentioned here, which is rules and regulations. So generally speaking, in the event of a conflict between these documents, the declaration will control as a document of highest authority. then it's the articles of incorporation, then the bylaws, and finally the caboose, although still important, is the rules and regulations. But I do want to mention one thing, is that a court will try to read documents together and interpret them together rather than declaring, oh, conflict, and we have to look to one over the other. Now, sometimes there are direct conflicts. And if there are direct conflicts, then that is the hierarchy, dec, articles, bylaws, and rules, which is why your rules cannot conflict with your declaration. So you can't pass rules that conflict with that, because the declaration will control and that rule will not be enforceable. We're going to start on meetings with membership meetings. So every association is required to hold a meeting of its members annually at a date, time, and place stated in or established through or in accordance with your bylaws. The election of directors must be held in conjunction with the annual meeting or as otherwise provided in your documents, but almost always the election is in connection with the annual meeting. Now, there may also be special member meetings in addition to the annual meeting. A special member meeting refers to a meeting of the membership other than the annual meeting, and typically that could be called by the board or by a percentage of your owners requesting or petitioning. If your documents are silent, then it's 10% of the owners requesting the meeting. However, most bylaws typically have a section or a provision regarding the percentage of owners who are entitled to request or petition a special members meeting. Okay, glitch in our thing for 2 seconds. Agenda. Unless the documents or the governing documents require otherwise, the notice of annual meeting does not require that there be a purpose or an agenda for an annual meeting. However, I highly, highly recommend that you do so anyway, that you do include the agenda and what you're doing at that annual meeting in your notice. Notice of a special meeting of the membership must include the description or purpose or purposes for what the meeting is called, and the business at a special members meeting is limited to just what is on that posted and mailed out agenda.
Sorry about that. That's me. That's not Peter, by the way. That's hitting the button on. There we go.
Okay. The notices of your membership meetings have to include the date, time, and location of the meeting. If the bylaws do not provide for giving of notice to the member meetings must be noticed at least 14 days in advance. I would advise do a 14 days in advance. If your bylaws have a lower, like a 10-day or something like that, I always advise to do the 14 days. Evidence of compliance with that 14-day notice must be made by an affidavit executed by the person providing the notice, which must be kept among the official records. And the notice must be mailed or delivered to the address identified as the owner's mailing address in the official records, or electronically transmitted if the owner has consented in writing to receive notice by electronic transmission. And we're going to mention this probably more than once today, and the fact that email notice is only done, again, if someone has agreed in writing to receive their notices in that manner. Okay. The association, and that's what's on the slide. The association may provide notice of any meeting by electronic transmission, which is email or fax, for those who still use fax, to any member who has consented in writing to receive notice by electronic transmission and have provided their email address or their facsimile number to the association for that purpose. The email addresses and fax numbers provided by members to receive notice by electronic transmission must be removed from the official records of the association when the member revokes that consent to receive notice in that manner. However, the association is not liable for an erroneous disclosure of an email address or fax number for receiving electronic transmission notice unless it was done intentionally. Now, electronic transmission, however, cannot be used as a method of giving notice for a meeting in which it's the purpose of it, in part or whole, is to recall a member of the board. For that, you have to use mailed or hand delivered.
I'm going to piggyback on one thing Peter mentioned about the association not being liable for erroneous disclosure of email. Same thing, Peter, correct, when it comes to being responsible for looking in your spam folders and other folders. If it doesn't appear in their inbox, It's up to the recipient to make sure that they're checking all of their inboxes to make sure that the email is in there somewhere,
That's
correct?
correct. It is, yeah, that's not even part of the thing, but you're correct. That is part of the law that if an owner has agreed to receive their notices by email, it's up to them to make sure that their spam filters don't trap it or get rid of it. That's not the association's burden. It's the owner's burden to make sure that their computer is not doing that to their
Their
emails.
server. And I want to say the same thing when we send our certificates out to all of you today. They're going to be coming from seminars at kbrlegal.com. So keep tabs on your spam folders in the next several days for that as well. Peter, back to you.
But otherwise, Jeff will hand deliver them to you and he'll fly into
Horse and
town.
buggy, horse and buggy.
We'll
Yeah.
do hand deliveries. Okay, notice requirements. In addition to sending notice to the members for their membership meetings, the association may, by rule, reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed circuit cable TV system serving the association. The notice and agenda must be broadcast in a manner and for a sufficient continuous length of time so as to allow an average reader to observe the notice and read and comprehend the entire content of the notice and agenda. I guess for Jeff, that would be like 2 days. For the rest of us, probably just a few minutes. Website posting. By January 1, 25, this year, by January 1, 2025, an association that has more than 100 parcels or 100 or more parcels or lots must post the notice and agenda of each scheduled members meeting at least 14 days before the meeting. And we're going to hear about this more today, but basically by January 1 of this year, if your association has 100 or more lots, then you're required to have a website and you're required to post the member meeting notices and agenda on that website. Members are, okay, excuse me. The notice must be posted in plain view on the homepage of the website. Again, or you can have an app which you can download to a mobile device, or on a separate page of the website or app labeled notices, which is conspicuously visible. The association must also post on the website or the app any document to be considered and voted on by the members during a membership meeting, or any document listed on the meeting agenda at least 7 days before the meeting at which the document or information will be considered. Now, every owner has a right to attend the membership meetings, and that right includes the right to speak on any items that are open for discussion or any items that were included on the agenda. And notwithstanding anything to the contrary, in your governing documents, an owner has the right to speak for at least 3 minutes on any agenda item or item that's open for discussion. Now, the association can adopt reasonable rules and regulations governing the frequency, duration, and other manner of owner statements. And those rules, however, must be consistent with those above provisions. So you can't, in other words, limit an owner's right to speak for less than the 3 minutes or less than every agenda or item open for discussion. The meetings must be held at a location accessible to physically handicapped persons if it is requested by a physically handicapped person who has a right to attend the meeting. And any owner has a right to audio or video record the meetings. You can adopt reasonable rules regarding the tapings of meetings, like you can't be running around and getting in people's faces and disrupting the meeting. Used to be in the old days, people would set up giant cameras and lights and everything like that. But nowadays, we all use our phones for the most part. But in any event, you can't adopt reasonable rules regarding the taping or the recording. Now, what's a quorum? A quorum is basically the number of members you need in order to conduct a meeting. Under the current law, unless your bylaws have a lower number, a quorum is 30% of the total voting interest of the association being at that meeting. That's in person or by proxy, assuming proxies are permitted in your association. Who makes a decision or what's the vote required? Well, unless otherwise required by law, meaning Chapter 720, or the governing documents, decisions that require a vote of the members must be made by the concurrence of at least a majority of the owners present in person or by proxy at which a quorum has been obtained. So if it's a majority of a quorum, then the vote is going to depend upon how many people are at that meeting in person or by proxy, and you'll have a sliding scale provided a minimum that you have a quorum. So that's a majority of that, provided there's a minimum of a quorum. Proxies. Unless otherwise provided by the statute 720.306 or in the governing documents, members have a right to vote in person or by proxy. So you do got to check your governing documents to see if there's any limit on proxy voting. To be valid, a proxy must be dated and must include the date, time, and place of the meeting for which it is given, and it must be signed by the authorized person who executed the proxy. In other words, the person authorized to sign that proxy on behalf of that lot or that parcel. A proxy is effective only for the specific meeting for which it was originally given, and any lawful adjournments of the meeting. However, it expires 90 days after the date of the meeting for which it was originally given. Now, this 90-day period is important. If you're trying to have a vote to say to amend your documents or some other kind of vote where the owners are authorized to vote and you don't have enough votes, you don't have to simply count the votes and say, oh, we're short. What you could do is, if you know you're not going to have enough votes, is that meeting could be adjourned and reconvened. Okay, those proxies are still good as long as the meeting is reconvened or continued within that 90-day period before the proxies expire. And you can do it multiple times within that 90-day period. Okay, proxies are revocable at any time by the person who executed it. Any proxy holder may appoint in writing a substitute proxy to act in his or her place if the proxy provides such a right to do so. What is the power of substitution? If someone names me, for example, as a proxy holder, but then I cannot make that meeting for some reason and it has a power of substitution, I can substitute someone else to be the proxy holder rather than myself. Okay. A copy of an original proxy can be used if it's complete reproduction of an entire proxy. And I get this question a lot. Is it okay to send a fax or an email of a proxy rather than the original? And the answer is yes, as long as it's a complete signed and dated proxy, then a copy is okay, or an emailed copy is okay. General versus limited proxies. I'm going to spend a couple minutes on this. A general proxy basically allows a proxy holder to vote however he or she wants on a matter that meeting is undertaking or that meeting is addressing. So if someone gives you a general proxy, you can vote any way you want on behalf of the person who gave you the proxy or named you as their proxy holder. A limited proxy basically lists the issues that the proxy holder may cast a vote for and instructs a proxy holder on how to vote. So a limited proxy, if I'm given a limited proxy and I'm the proxy holder, on the face of that proxy, it'll say that the owner is voting yes or no or whatever on that issue, and I can't exercise my judgment as a proxy holder. So it's almost like the first cousin of an absentee ballot, in that the limited proxy, the proxy giver, is basically instructing the proxy holder how he or she must vote on those listed issues. And just so there's no confusion between HOAs and condos, in a condominium, because some of you may think, well, that's not right. We know that limited proxies have to be used. In a condominium association, by law, by statute, substantive issues are voted on by limited proxy. They can't use general proxies. And in a condominium association, you also can't vote in elections by proxies. You have to use secret ballots. So condominiums are different. In an HOA, it really depends what your documents say. General, you can have limited. If it's silent, then you can have general. So you really got to check out your documents for any restrictions on proxy voting in an HOA. Electronic voting, or in other words, voting online, versus, by clicking. Now, in an HOA, the use of an internet-based online voting system must be established by board resolution made at a board meeting, and you have to give 14 days notice of that meeting by mail, delivery, or electronic transmission. Again, electronic transmission only to those who have agreed to receive it that way. And you have to post notice conspicuously at least 14 days in advance. And again, there's an affidavit that these 14-day notice requirements were met, provided by the person in the association who is providing that notice. That board resolution must provide the owners or the members will receive notice of the opportunity to vote through an online voting system. It must establish reasonable procedures and deadlines for members to consent electronically or in writing to online voting, establish reasonable procedures and deadlines for members to opt out of online voting after they gave their consent. And the association may conduct membership voting through the online voting system if a member consents electronically or in writing to online voting, which is valid until the owner opts out of online voting. An owner voting electronically is counted as being in attendance at the meeting for purposes of determining a quorum. And just as an aside, I have, several associations who have adopted online voting, and they find it very successful. They find it, it makes it, easier to run their meetings when they have online voting, as well as they may have, regular voting, but they seem to like the online voting. By the way, the online voting, you acquire that software by vendors or certain companies that will sell you online voting software. If online voting is used, each owner must be provided with a method to authenticate the owner's identity, a method that is consistent with the association's election procedures and its bylaws, and we'll get to that in a few minutes, a method to confirm at least 14 days before the voting deadline that the owner's electronic device can successfully communicate with the online voting system. Now, the association's online voting system must be able to authenticate the owner's identity, authenticate the validity of each electronic vote to ensure the vote is not altered in transit, transmit a receipt to each owner who casts an online vote, and permanently separate any authentication or identifying information from the electronic election ballot, rendering it impossible to tie a ballot to an owner if the association's bylaws provide for secret ballots for the election of directors. And again, this is a bylaw-driven issue for HOAs. And the system must be able to store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. Getting into elections now. The election of directors. If a vacancy on the board is caused by the expiration of a director's term, then it's filled by election. So as opposed to resignation or death or something like that, if it's through expiration of a term, then their successor is elected. Elections must be held, as we mentioned before, or in conjunction with the annual meeting, or as provided in your documents. Elections must be conducted in accordance with the procedures set forth in the governing documents. I'm going to stop here for a second. Elections must be conducted in accordance with the procedures set forth in your documents. The HOA Act does not set forth the procedure to conduct elections. It defers to your bylaws. Unlike condominiums, in which the election is governed almost entirely by the statute. So 718 is much different than 720. And in 718, back in the early 90s, they came up with the secret ballot method, the 2 envelopes, the 60-day notice. And I've noticed a lot of HOAs, for whatever reason, use that procedure because it's been around now for a long time, 30, 40 years, 30 or plus 30 years, even though their bylaws may have a different procedure. So my little nugget of information here is don't assume because condos do this certain statutory procedure that applies to you. You have to do, when I say you, the HOA boards must conduct their elections in accordance with the HOA documents. Okay, moving on. Unless otherwise provided in the governing documents, a quorum of the members must be established in order to conduct an election and any other business of the association at the annual meeting. There's one exception to that we'll get to in a second. But again, a little divergence here. Condos, there is no quorum requirement for an election, except that 20% of the people must cast a ballot. In an HOA, you must have a quorum, which, as we mentioned before, is at least 30%, unless your documents have a lower number, unless your bylaws in your election procedure have a different percentage or a different requirement for an election meeting as far as quorum goes. Finally, unless otherwise provided in the governing documents, directors are elected by a plurality of the votes cast. That means who gets the most votes. You don't have to get a majority of all the votes. You have to get a plurality of the votes. Who's eligible to serve? Well, all members of the association are eligible unless otherwise disqualified. And we'll get to that in a second here. How are you disqualified? If you're delinquent in the payment of any monetary obligation, that's any monetary obligation to the association on the day that he or she could last nominate himself or herself or be nominated for the board, that person cannot seek election to the board and their name cannot be listed on the ballot. So if you're delinquent in any payment to the association as of the last day to place your name into nomination or be nominated, you can't run for the board. If you've been convicted of a felony in Florida or in any U.S. district or any territorial court or any offense in another jurisdiction, which would be considered a felony if done in Florida, you're not eligible to serve or run for the board unless your civil rights have been restored for at least 5 years as of the date on which you're seeking election to the board. Now, a person who has pending criminal charges, not conviction, but if you have a pending criminal charge for forgery of a ballot envelope or a voting certificate, felony theft or embezzlement of an offense involving association funds or property, tampering with physical evidence, including the destruction or the refusal to allow timely inspection or copying of a record in furtherance of a crime and obstruction of justice, you may not be elected. So those things, even if you've just been, not accused, even if you've just been charged, you can't serve on the board. You don't have to be convicted. Nominations. And this is very different. And again, for condo land, for nominations for an HOA board, you can nominate yourself as a candidate for the board at a meeting where the election is to be held, unless the election process in the governing documents provides for a pre-nomination procedure, maybe similar to condos. But if it's a pre-nomination procedure, then the association is not required to allow nominations at the meeting. So check your documents. Election day, ta-da! An election is not required unless more candidates are nominated and vacancies exist. So if you have, 5 vacancies and 5 or fewer candidates, then they're elected by acclamation. If an election is not required because there is equal number or fewer qualified candidates and vacancy exist, and if nominations from the floor are not required, then the qualified candidates commence service on the board at the annual meeting, regardless of whether a quorum is obtained. So this is the exception. You have to have a quorum. If you have an election, okay, and there's no nominations from the floor, so you have pre-nominations, and let's say you have 5 vacancies. If you have 5 or fewer candidates who have pre-nominated themselves, then they're automatically elected, even if there is not a quorum at that meeting, because there's no nominations required for that particular association from the floor at the annual meeting. As far as voting, members have the right to vote in person or by proxy unless otherwise provided in your governing documents. If your governing documents permit voting by secret absentee ballot, again, and that has to be authorized by your documents. The statute doesn't by itself authorize it. So if the governing documents permit voting by secret absentee ballot, the ballot must be placed in an inner envelope with no identifying markings and mailed or delivered to the association in an outer envelope, which identifies the name of the member or owner, the lot for which the ballot is cast, and the signature of the member casting the ballot. All ballots and proxies are tabulated on the day of the annual meeting. If more than one ballot is submitted for a parcel or a lot, the ballots for that lot are not counted or disqualified. Any vote by ballot received after the closing of the balloting is also not considered. And unless otherwise provided by your documents, directors serve a 1-year term. Now, some documents have staggered boards of multiple years, either 2 or 3 typically. In that case, then they serve more than 1 year. If it's silent, they serve 1 year. Challenges. When can you challenge? Any challenge to the election process must be commenced within 60 days after the election results are announced. So let's say, for example, that you totally mess up your election process. You didn't follow your bylaws correctly. You didn't do the process correctly, whatever. However, if 60 days pass or more than 60 days pass from the election, then, technically you did everything correct because it's too late to challenge. I'm not recommending that, but just an aside. Now, where are election disputes heard? The venue for an election dispute is either binding arbitration with the division, which is the Division of Florida Condominiums, Timeshares, and Mobile Homes. It's one of the few things that the Division of Condominiums basically has jurisdiction when it comes to HOAs, or the matter is filed with a court of competent jurisdiction. Election disputes submitted to binding arbitration with the division must be conducted in accordance with 718-1255, which is part of the Condominium Act. Election of officers. We just talked about board members. Now, officers generally or typically under almost all bylaws and documents that I've read are appointed or elected by the board immediately following the election of the directors at the organizational meeting. Check your bylaws, by the way, for when your organizational meeting must be held. And another thing I'm going to mention here, don't just meet in a back room, okay? For years, I've seen associations after their annual meeting, the new board members then adjourn to a back room somewhere to elect their officers. The officer election is a board meeting that needs to be noticed just like any other board meeting and needs to be open to the membership. However, at that meeting, although directors cannot vote by proxy or secret ballot at board meetings generally, secret ballots can be used in the election of officers. It's the only time that board members can that board members can vote by secret ballot. They still can't use proxy. Board members can't vote by proxy, but when they elect officers, they can vote by secret ballot. And there's no prohibition typically against changing officers midterm. So usually under most bylaws, officers serve at the pleasure, or maybe a better term is displeasure, of the board, and the board can change officers. The board can't remove a director, but they generally can remove an officer. So if someone, let's say, is a president, they can vote in a different president. That person still stays on the board, but now someone else will be president or vice president or whatever office may be involved. Fraudulent election voting activities, and hopefully this will not apply to anyone who is on this Zoom, but just be aware that a person who engages in these following acts of fraudulent voting activity commits a first-degree misdemeanor. So what are they? Falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to or affirm an oath in connection with or arising out of a voting activity, perpetuating or attempting to perpetuate or aiding in the perpetration, or perpetration of fraud in connection with a vote cast or to be cast or attempted to be cast, preventing a member from voting or preventing a member from voting as he or she intended by fraudulently changing or attempting to change a ballot envelope, or voting certificate, and menacing, threatening, or using bribery or any other corruption to attempt, directly or indirectly, to influence, deceive, or deter a member when the member is voting. So, pretty bad actions for these fraudulent. What else? Other things that are fraudulent voting activities. Giving or promising, directly or indirectly, anything of value to another member. In other words, buying someone's vote, okay? That does not apply to any food served, which is to be consumed at an election rally or meeting, or any nominal item of nominal value, which is used in election advertisement. In other words, giving someone a campaign flyer or a pin or something like that. All right. Using or threatening to use directly or indirectly force, violence, or intimidation, or coercion to induce or compel a member to vote or refrain from voting. Yeah, so we can't be intimidating, coercing, or threatening people about their votes. Now, effective July 1 of last year, each of these actions constitute a first-degree misdemeanor. Knowingly aiding, abetting, or advising a person in the commission of a fraudulent voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, having knowledge of a fraudulent election voting activity, and giving aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. Now, what about vacancies that occur before the expiration of a term? In other words, by death, resignation, disqualification, those kind of things. Unless otherwise provided by the bylaws, any vacancy that occurs in that manner may be filled by the affirmative vote of a majority of the remaining directors, even if the remaining directors are less than a quorum or only one remaining director, there's only one person left. Alternatively, the board may hold an election to fill those vacancies. Although in my experience, usually the board, unless their bylaws prohibit it, will appoint or elect someone to fill that vacancy. Finally, unless otherwise provided by the bylaws, the board member who is appointed or elected to fill a vacancy created in by death or resignation, something like that, that person fills that vacancy for the unexpired term of the seat being filled unless the bylaws provide otherwise.
And while
Board voting
Peter's
decision.
sitting, real quick, just for those of you that may have joined a few minutes late, remember this is for Homeowners Association board members. Peter's done a few comparisons to condominium associations. So just to avoid any potential time wasting for any of you that might be on a condo board, this is for certification of HOA board members. Back to you, sir.
Yeah, it is HOA. I just mentioned the condo, comparisons, just so people don't get confused between the two. Okay, board voting and decisions. Often directors have a fiduciary responsibility to the owners. What's fiduciary? That's basically a trust, okay? Now, they must act reasonably, and the reasonable business judgment rule, real quickly, that will typically protect the board member from liability, okay? As long as you're acting reasonably, and in good faith with the best interests of the corporation in mind. You don't always have to be correct. You don't always have to be right. Okay. As long as, again, acting in good faith and acting reasonably. That's the reasonable business judgment rule, basically. Unless otherwise provided by your governing documents or by applicable law, the association's powers are exercised by the board. So generally speaking, almost everything an association does, except for, where the law or your documents, provide otherwise, is done through board action as opposed to owner vote. Unless delegated, no individual board member should be making decisions for the board. So I know some places, the president, for better or for worse, wields enormous power, but really every board member is equal in terms of having the ability to operate through a consensus what that association is doing, what it's deciding, how it's implementing the powers, unless for some reason they've delegated to a board member certain exclusive powers.
Hey, Peter, this is going to come up 20,000 times as we get into this section. So let's head it off at the pass. Let's say the majority of the board wants to meet for dinner. Is that a
And we're
board
going to get
meeting?
to that. Yeah, we're
Okay.
going to get to that. That is coming up.
All right.
It's on an individual slide.
Okay.
Okay. As mentioned a couple times, you can't vote by secret ballot or proxy unless you're electing officers. Then you can use secret ballot. You can communicate with each other, board members, by email, but you cannot vote by email. Okay. All board meeting notices must include the date, time, and more recently, and it changed the law, the agenda for the board meetings. That must be on your posted or sent notice, depending on the type of board meeting. An assessment may not be levied at a board meeting unless the notice of the meeting includes a statement that assessments will be considered and the nature of the assessments. Now, unless the bylaws provide otherwise, notices of all board meetings, with a few exceptions, must be conspicuously posted with the information we just mentioned at least 48 hours before a meeting. Conspicuously posted within the community, except in an emergency, but it has to be a bona fide emergency, okay? A bona fide emergency. A bona fide emergency is not that the board members are all leaving next week to go up north, okay? Bona fide emergency, hurricanes, other things like that. 14-day notice. Now, again, certain board meetings need more than a 48-hour notice. Which are those? Also, otherwise provided by the bylaws, written notice of any meeting at which special assessments or an amendment to a rule regarding the use of a lot will be considered must be mailed, delivered, or electronically transmitted to all the owners and posted conspicuously on the property in the community at least 14 days before the meeting. In addition to other notice methods, the association may adopt a rule and a procedure for conspicuously posting board meeting notices and the agenda on your website or on the app for at least the minimum period of time for which the notice was required to be physically posted, whether either 48 hours or 14 days. Any rule adopted must include a requirement that the association send electronic notice to members whose email addresses are included in your official records, in the association's official records, in the same manner as is required for notice of a meeting of the members. And such notice must include a hyperlink to the website or the app on which the meeting notice is posted. We mentioned this a couple times. Here's a separate slide for it. By January 1 of 2025, if your association has 100 or more lots, you are required to have a website or an app downloaded to a mobile device, and you have to post your board meeting notices, the agenda, and any other document required for that meeting no later than the date required for the notice. It must also be posted on the website or the app. Member participation at board meetings. Similar to membership meetings, all meetings of the board are open to all members, except for, actually, I didn't mean to say that. I was going to talk about participation. All meetings are open, except for meetings between the board and the attorney with respect to proposed or pending litigation where the contents of the discussion would otherwise be governed by the attorney-client privilege. That doesn't mean you can just meet with the attorney any old time you want and close the meeting. It really is required to be in connection with pending or proposed litigation in which you're seeking advice regarding the same, and any meeting of the board held for the purposes of discussing personnel matters. Those are the only two types of board meetings which are closed, okay? The owners don't have a right to attend. Members have a right to attend all board meetings, okay, except as we just mentioned above, and they have a right to speak on any designated item any agenda item, anything that comes up for discussion. Similar to membership meetings, the association can adopt reasonable rules governing the frequency, duration, and other manner of member statements, including, for example, a sign-up sheet, if you want to do that, for members wishing to speak. Unlike a member's right to speak at members' meeting, there's no statutory prescribed time limit for a member to speak at board meetings. In other words, for member meetings, it's a minimum of 3 minutes. There is no statutory minimum for a board meeting. However, I would adopt 3 minutes. I think that's a good time frame to adopt for a board meeting as well, unless your bylaws have, some longer period of time. Handicapped access. An owner, similar to member meetings, an owner can audio or video record board meetings. Again, you can adopt reasonable rules regarding that recording. And similarly to the membership meetings, board meetings must also be held at a location accessible to physically handicapped if it is requested by a physically handicapped person who has a right to attend the meeting. Directors and officers of committee members don't get paid, sorry, except for limited circumstances. They don't get paid any compensation for fulfilling their duty as a director, officer, or committee member. They can participate in financial benefit accruing to all or significant number of the members as a result of actions lawfully taken. They can be reimbursed for out-of-pocket expenses incurred on behalf of the association, subject to applicable approval procedures, typically approved by the board. Recovery of insurance proceeds derived from a policy of insurance maintained by the association for the benefits of members. Now, a fee or compensation can be authorized either by your governing documents or by a vote of a majority of the voting interest, voting in person or by proxy at a meeting of the members. Doesn't happen too often. Kickbacks. In short, don't take them. What is a kickback? Basically, a kickback is if you're getting anything of service or value for which you have not provided due consideration, and that thing is being provided to your benefit, or a manager's benefit, or a benefit of an immediate family member, for any person proposing to provide goods or services to the association. So you can't take money. You can't say, hey, paint my house when you're painting all the other homes in the community. You don't pay for the painting for your house or whatever. All I'm saying is, you can't be taking kickbacks. Anyone who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. An officer or director violating that provision is also immediately removed from the board, creating a vacancy. Now, what can you do or can you accept? You can accept food to be consumed at a business meeting with a value of less than $25 per person, or service or goods received in connection with a trade fair or an education program.
Peter, I want to just clarify something that I think applies here as well, because this came up in the condo class earlier this week. Kickback. Well, as it relates to kickbacks, that's not just getting something for free. That's anything of value, meaning like,
A
hey,
service.
I'll paint your house for $10.
I just said, yeah.
Okay.
Anything of value, that could be a service or actual money, anything of value that you're not paying consideration for or providing consideration for. A director or officer charged, again, just charged, not convicted, by information or indictment with any of these things must be removed from office. I think we mentioned some of these already. Forgery of a ballot envelope or voting certificate used in an election. Theft or embezzlement involving association funds. Or property. Tampering with physical evidence as provided in 918.13 Florida statutes. Destruction or the refusal to timely allow inspection or copying of an official record in furtherance of any crime, obstruction of justice, or any criminal violation under the HOA Act. Charge with any of this stuff, you're off the board. Now, the board must fill the vacancy until these people are suspended, in essence, until those charges are dropped, or they're found to be not guilty. Okay, so the board is required to fill the vacancy until the end of that suspension. However, if the charges are resolved without a finding of guilt or without acceptance of a plea of guilty or nolo contendere, the director or officer must be reinstated. So again, the charges are dropped or they're found not guilty, then the person is reinstated. If the criminal charge is pending, any of those charges are pending, then that person may not be appointed or elected to a position as an officer or director of any association, not just the association they were serving for or serving of, but any association, and may not have access to official records of any association except pursuant to a court order. Now, this is really important. A director who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligations, that's any monetary obligation, that could be, anything that they owe the association, is deemed to have abandoned his or her seat, creating a vacancy. And that's not just a suspension. That means you're off the board. You're off the board, and then the remaining board members will fill that vacancy. Conflict of interest, disclosures. Directors and officers, including those that were appointed by the developer, must disclose to the association any activity that may reasonably construed or be construed to be a conflict of interest at least 14 days before voting on an issue or entering into a contract, which is the subject of the conflict. There's a rebuttable presumption of a conflict if any of the following acts occur without prior disclosure to the association. So first, a director officer or a relative of a director officer enters into a contract for goods and services with the association. Or a director officer or a relative thereof holds an interest in a corporation, an LLC, a partnership, a limited liability partnership, or any other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. Those are all conflicts. So, if an association enters into a contract or other transaction with one of its directors or officers, or a corporation or other entity in which the director is also a director or officer or is financially interested, excluded an affiliated HOA, then the board must comply with these following requirements. That proposed contract with the director must be fully disclosed to the board, and a disclosure entered into the minutes of the board meeting at which that proposed contract will be considered and voted upon, and it must be approved by a 2/3 vote of the directors present. The contract must be fair and reasonable with respect to the association. At the next regular or special meeting of the membership, the existence of the contract or that transaction with that director must be disclosed to the membership. And at that membership meeting, upon a member's motion, that contract or transaction may be canceled by a majority vote of the members present. If the members cancel the contract, the association is only liable for the reasonable value of goods and services provided up to the time of cancellation and is not liable for any termination fee, liquidated damages, or other penalty for such cancellation. Just as an aside, unless there's a compelling reason to enter into a contract with an officer or director or the family member of an officer director, I quite frankly would avoid it. Again, unless there's some compelling reason to do it. And if you are going to do it, then please, please, please follow this procedure to the T. Official records. Okay. Very important. What are they? Here's a list. The official records of the association include copies of any plans, specifications, permits, and warranties related to improvements on the common area or other property the association is obligated to maintain, repair, or replace. All of your governing documents, that's your declaration, articles, bylaws, and rules, and all the amendments to those documents. You must include adequate copies of those documents to ensure their availability to the members and prospective members. Minutes of all meetings, both of the board and of the membership. A current roster of all your members and their designated mailing addresses and lot identifications, in other words, the lot legal descriptions, and the email addresses and facsimile numbers for those members, if any, who have consented to receiving their notice by electronic transmission and haven't revoked that consent. Your insurance policies, a copy of all contracts to which the association is a party, all bids received, that's all bids received, not just the ones that you've accepted for any work to be performed. The financial and accounting records must be kept according to good accounting practices, and these are all part of your official records, including accurate and itemized and detailed records of all receipts and all expenditures. A current account and a periodic statement of the account for each member, designating the name and current address of each member who is obligated to pay assessments, the due date and amount of each assessment and or other charges against the member, the date and amount of each payment on that member's account, and the balance due on that member's account. All the tax returns of the association, financial statements, and financial reports. You also must include the disclosure summary, which is required under 720.401. As far as meetings and elections go, you have to maintain your ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by owners. These must be kept for at least 1 year after the date of that election, vote, or meeting. All affirmative acknowledgments made pursuant to 72308. 5, subsection 3. Those acknowledgments deal with the manner in which an owner receives their assessment notification, and that's going to be talked about briefly further on. Finally, there's a catch-all. All other written records of the association that are not specifically identified above, or I already mentioned, which are related to the operation of the association. Now, you have to maintain your official records for at least 7 years, unless your documents require a longer period. Bids, which are received, must be kept for at least 1 year. And remember, all your election materials and voting materials, they must be kept for at least 1 year too. Now, effective last year, July 1, 2024, in a new statute or new change to the statute, the association must adopt written rules governing the method or policy by which the official records of the association are to be retained, and the time period such records must be retained. Such information must be made available to the owners through the association's website or app. Now, certain things are not accessible, okay, that owners are not entitled to obtain even when they make a records request. So what are those? Records protected by the attorney-client or the work product privilege relating to litigation. We'll talk about a little more detail in a second. If you have the authority under your documents to approve or disapprove the sale, lease, or transfer of a lot, then any information that you obtain in connection with the approval or disapproval of a lease, sale, or other transfer of a lot is privileged and not accessible to other owners. If you have a gated community, information obtained in connection with a guest visit to owners or residents is not accessible. Social security numbers, driver's license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, and emergency contact information, and any address other than provided for association notice requirements and other personal identifying information, excluding your name, the owner's name, lot designation, mailing address, and property address. All that stuff is privileged. Now, if someone has given their email address as their official address for receiving notices from the association and can send that in writing, then that email address is not privileged, okay? But if someone has not consented to their email address being used for official notices, then that email address is privileged and is not accessible to other owners. Now, the association is not liable for disclosure of protected information if the information is included in an official record and is voluntarily provided by the owner and has not been requested by the association. Other things that are not accessible: personnel records of association or management employees. By the way, that does not include a management contract or a manager's contract. That's a record. That's something that is accessible. But other personnel records, whether it's payment history, suspension, discipline, those kind of things. Now, if their amount that they're paid is in your budget and it's a line item in the budget, then it is accessible. That's just an aside. Medical records of owners or residents are not accessible. That would include anything you receive from an owner requesting service support animals or things like that. We'll get to that towards the end of the presentation. Electronic security measures that are used by the association to safeguard data, including passwords, are not accessible. The association's software and operating system, which allows the manipulation of data, even if the owner owns a copy of the same software used by the association, and the affirmative acknowledgments under 723.085 are not accessible. And we mentioned attorney-client privilege. This is very important. Basically, attorney-client privilege is anything that the board sends to their attorney or the attorney sends to the board, whether it's emails or letters or whatever, okay? Those are all privileged, that communication back and forth. Now, if the attorney writes to an owner or if an attorney writes to a third party, that is not privileged, just as an aside. Work product privilege is also privileged. What are work product privilege things? That's any record prepared by the attorney or prepared at the attorney's express direction, which reflects a mental impression, conclusion, litigation strategy, or legal theory of the attorney or the association and which was prepared exclusively for civil or criminal litigation or for adversarial proceedings, or which was prepared in anticipation of that stuff, litigation proceedings, until the conclusion of the litigation or the proceedings. So there's two types of attorney things that are privileged: the direct attorney-client communications and the work product under the attorney's direction, which is also privileged. Now, correspondence or other communication from the attorney, from the associate's lawyer, remains privileged unless the board votes to waive the privilege. The attorney cannot waive that privilege. Only the board can waive the attorney-client privilege. Now, you are permitted to print a directory containing the name, lot address, and all phone numbers of each owner. However, an owner may exclude his or her phone number from the directory by so requesting the association in writing. So if you're going to do this, give the owners a reasonable amount of time to opt out or exclude their phone numbers from the directory. Now, an owner can also provide written consent to the disclosure of other contact information which is otherwise not accessible. So if an owner agrees in writing that his or her email address, for example, can be provided to other owners or their phone numbers or something like that, then you can do it. But it has to be with that owner's written consent. There was a new statutory requirement effective July 1 of last year, which provided that before October 1st of last year, an association was required or is required to provide a physical or digital copy of the association's rules and covenants to every member, every owner. An association must provide a physical or digital copy of the association rules and covenants to every new member, so everyone who acquires a lot or parcel. If the rules or covenants are amended, then you must provide every member with an updated copy of the amended rules or covenants. An association may adopt rules establishing standards for the manner of distribution and time frame for providing copies of the updated rules or covenants. And you can comply with this requirement by posting a complete copy of the rules and covenants or direct link on the homepage of the association's website, if the website is accessible to the owners and the members. And the association sends notice to each member of the association of its intent to utilize the website for that purpose by email, again, to any member who has consented to receiving notices by electronic transmission and has provided an email address to the association for that purpose, and by mail to all the other members at the address identified as the member's mailing address in the association's records. Access to records. So we mentioned owners have access to records, except they don't have access to all records. Unless otherwise provided by law or your governing documents, the official records must be made available in copying by an owner within 45 miles of the community or within the county that the community is located in, and it must be provided within 10 business days after receipt of a written request from an owner. To comply with these requirements, you have a choice. You can make them available for inspection or copying at the community. You can make the records available electronically via the internet, or you can allow the records to be viewed in electronic format on a computer screen and printed out upon request. Excuse me. If the request is submitted by certified mail from the owner, return receipt requested, and the access is not timely provided, there is a rebuttable presumption the association willfully failed to comply. So if you get a certified mail request, I'm not saying every request is important, but certified mail requests, if you don't comply, will create this rebuttable presumption you willfully failed. A member denied access to official records is entitled to their actual damages, if any, or minimum damages for the association's willful failure to comply. The minimum damages are $50 a day up to 10 days, in other words, $500. The calculation starts on the 11th business day after receipt of the written request. If an association receives a subpoena for records from a law enforcement agency, then you must provide a copy of such records or otherwise make the records available for inspection and copying to the law enforcement agency within 5 business days after receipt of the subpoena, unless otherwise specified in the agency, by the agency or in the subpoena. An association must assist a law enforcement agency in its investigation to the extent permissible by law. Official record crime. So There are crimes related to basically failing to provide the records or obstructing the provision of the records. So what are those crimes? This is also pretty new, effective last year. Any director or manager who knowingly, willfully, and repeatedly, which is 2 or more times in a 12-month period, fails to provide access to the official records with the intent of causing harm to the association or to one or more of its members commits a second-degree misdemeanor. Any person who knowingly and intentionally defaces or destroys accounting records during the period in which such records are required to be maintained, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created and maintained with the intent of causing harm to the association or one or more of its members commits a first-degree misdemeanor. Any person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape commits a third-degree felony. Hopefully, none of this will apply to anyone that's listening, watching. An association may adopt reasonable rules and regulations regarding the frequency, time, location, notice, the records to be inspected, and the manner of inspection. However, those rules cannot require an owner to show any proper purpose for the inspection, require an owner to state any reason for the inspection, or limit an owner's right to inspect records to less than 1 8-hour business day per month. I want to emphasize here that it's not the board's business, and you really have no right to know why an owner wants the records, what purpose they want the records for, even if this person is, for whatever reason, your worst enemy, or he or she is the gadfly of the association, or the pain in the whatever of the association, all that stuff. It doesn't make a difference if it's your best friend or your worst enemy. You have to provide access to the records, and you can't question why they want them. Now, as far as copying and charging for that, an owner or their representative, their authorized representative, is allowed to use a portable device, such as a smartphone, a tablet, or a scanner, or any other technology capable of scanning or taking photographs to make electronic copy or photograph of the records. And the association cannot charge for that. So if I want to use my smartphone or my tablet to take pictures or take photographs of the records, there's no charge by the association. Now, if the association has a photocopy machine or equipment available where the records are maintained, it must provide owners with copies on request during the inspection if the entire request is not more than 25 pages. You can charge up to 25 cents per page for the copies made on the association's copier. If you do not have a copier, or if the records requested to be copied exceed 25 pages, then you may have the copies made by an outside service, duplicating or copying service, and may charge the actual cost of the copying as supported by the vendor's invoice, or the place's invoice. Personnel costs. The association may charge for the costs required for personnel to retrieve and copy the records if the time spent retrieving and copying exceeds a half an hour, and if the personnel costs do not exceed $20 per hour. However, please note that personnel costs may not be charged for record requests that result in the copying of 25 or fewer pages. Website. We've talked about this a few times, but we're going to do it again briefly. Again, by January 1 of this year, associations with 100 or more lots were required to create a website or an app for the posting of the association documents. That website or app must be accessible through the internet and must contain a subpage, web portal, or other protected electronic location that's inaccessible to the public, the general public, and only accessible to the members and employees of the association. Upon written request from an owner, the association must provide the owner with a username and password and access to those protected sections of the website or the app. These are the documents that must be posted on the website or the app. The governing documents, again, declaration, articles, bylaws, and all the amendments. The current rules, which includes, as currently amended. A list of all the current executory contracts or documents to which the association is a party, or under which the association or the owners have an obligation or responsibility. And after bidding for the related materials, equipment, or services has closed a list of bids received by the association within the past year. The annual budget and any proposed budget to be considered at the annual meeting, even though between you and I, generally budgets are considered at board meetings, not annual meetings. But if your association considers the budget at the annual meeting, that must also be posted. The financial report and any monthly income or expense statement to be considered at a meeting. The association's current insurance policies and the certification, like today's certification of each director.
I'm going to mention something because this comes up with every HOA class. In one of the earlier slides, Peter, we talked about official records, and it's all of the contracts. The executed contracts were mentioned as something that has to be provided as on request. But here it says a list of the contracts. So on the website, can it just be a list listing what the contracts are, or must it actually be a copy of the contract?
I think it's just a list.
Okay.
But I have no objection to posting the entire thing.
Right. Because it's on the other requirement. So it's kind of,
Yeah.
yeah. Okay.
No, well, it has to be part of your records, but not all your records are on the website.
Good point. Okay. Next slide.
All right. Also posted, now here you do have to have the contract. All contracts or transactions between the association and any officer, director, or corporation, firm, or association that is not an affiliated HOA, or any other entity in which an association director is also a director or officer and financially interested, any contract or document regarding conflict of interest or possible conflict of interest. And remember, we talked about conflict of interest. Any of those contracts that basically are a conflict of interest contract or transaction, that is posted. Notice of any board meeting, the agenda, and any other document required for the meeting, which must be posted no later than the date required for the notice. Notice of any membership meeting and the agenda for the meeting at least 14 days before the meeting, posted in plain view on the home page of the site or on a separate subpage of the website labeled Notices, which is conspicuously visible and linked from the home page. The association must also post any document to be considered and voted on by the members during the membership meeting, or any document listed on the meeting agenda at least 7 days before the meeting at which that document or information within a document will be considered. The association must ensure that the information records which are not allowed and are not accessible are not posted. So all that stuff I mentioned before that was privileged and not accessible to other owners, that is not posted on the website. If protected information or information restricted from being accessible to owners is included in documents that are required to be posted, then you have to redact that before you post it. So if you have privileged information or not accessible information that happens to be included within a document that is required to be posted, that has to be redacted out before it's posted. However, the association or its authorized agent is not liable for disclosing protected or restricted information unless such disclosure was made with a knowing or intentional disregard of the protected or restricted nature of that information. But I would still strive not to post information that is protected, privileged, or inaccessible to the other owners. Amending the governing documents. Okay, what vote is needed? Well, unless otherwise provided, and typically it does, but unless otherwise provided or in the documents or by law, any governing document may be amended by the affirmative vote of 2/3 of the voting interests of the association. Amendments to the articles and bylaws which affect or impose a quorum or voting requirement greater than that are not required. Proposed amendments must be formatted to show text in underline and deleted and strikeout. This is very important. Basically, if you're changing a provision of your document, you have to strike out the language that's being deleted, underline the language that's being added, and you must show the full provision that's being changed, that entire provision. However, the exception is if the proposed change is so extensive that that formatting ends up being confusing or hindering the understanding of the amendment, then the following notation must be inserted immediately preceding the proposed amendment. Substantial rewording, see governing documents for current text. So let's say, for example, you're amending and restating the entire declaration. It'd be very difficult to show and strike through and underlining. You can just say substantial rewording See governing documents for current text and just show the amended language without the strikeouts and without the underlining. Now, some documents or some governing documents require lender or mortgagee consent to amendments. Under section 72306, 1D, that addresses the process of amending the governing documents when mortgagee consent is required. It only applies to certain mortgagees. If after 60 days there is no response, the lender is deemed to consent to the amendment. An amendment to a governing document is effective when recorded in the public records of the county in which the community is located. Within 30 days after recording an amendment, the association is required to provide copies of the amendment to the members. However, if a copy of the proposed amendment is provided to the members prior to the vote, and that amendment wasn't changed prior to the vote, then you can provide notice to the members that the proposed amendment was adopted and a copy is available upon request at no charge. This notice must also provide the official records book and page number or instrument number of the recorded amendment. However, the failure to provide notice of the recording of the amendment does not affect the validity or enforceability of the amendment. Things you should know about things, about stuff you should be aware of. Governmental filings. There's 2 governmental filings you have to do. Every year, you have to maintain your active corporate status by filing an updated annual report with the Division of Corporations. That includes names of the directors, typically labels what office they hold, who's a registered agent for the association, also includes the association's official mailing address, and like I said, who is the registered agent. You also have to file an annual income tax report. Contrary to popular belief, not-for-profit corporations under Chapter 617 are not tax exempt. Okay, that's a 503c corporation under the IRS code, things like churches or educational institutions. An association, an HOA or a condo created, and we're talking about HOAs today, established under Chapter 617 still must file their tax return. Meeting minutes. All meetings must have minutes, board member meetings and membership meetings. Minutes do not have to be verbatim, nor should they be verbatim. The minutes should not reflect every word that was mentioned at a meeting. They should reflect the minutes of the business that was taken at the meeting. In other words, what motions were made, who made the motion, who seconded the motion, what is the motion, what is the resolution, and then what was the vote on that resolution. I would not include everyone's comment or discussion that Betty said this and Joe said this and Sue said this. That's really not appropriate for the minutes. They must be in written form or in another form that can be converted to written form within a reasonable time. And this last bullet point, a voter abstention from voting on each matter voted upon for each director must be recorded in the minutes. So it's not sufficient to say that the motion passed 4-3, or the motion failed 4-3, or 5-2. You have to indicate how each director voted, or if they abstained. So did they vote yes, no, or abstain? And that's reflected in the minutes. Now, material alterations, just a couple seconds on this, or a minute. Material alterations basically are changes to the common area, okay? The leading case was a condo case because there aren't really any HOA cases. And a material alteration was deemed to be to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. Now, Jeff doesn't like it when I do this, I think, but condominium law is very specific about material alterations to common elements. It's an entire section of the statute about it. HOA Act, though, we're doing today, is silent. So the HOA Act does not address material alterations to the common area or what vote is needed. So since the HOA Act does not require a membership vote, you have to look to your governing documents. And I've seen governing documents that expressly say board can approve alterations. I've seen HOA documents that expressly say that owners must approve material alterations to the common area. It really depends. And you got to study the documents carefully to determine what vote or who is needed and who's authorized to make that vote, either the board, the owners, or both.
Peter, I love everything you do. And since this is being recorded, I think this makes it an official record that I said that, right? So
Thanks, Dad. Uncle Jeff. Okay,
Oops, I didn't mean to do that. Hang on.
that's right. You just like yourself.
Now you can take a sip of water. There you go.
Okay, rules and regulations. Now, contrary to popular belief, or maybe mythology, uh, associations or boards don't have an inherent authority to adopt rules and regulations. Now, you may adopt, when I say you, the board and or the owners, depending on what your documents say, may promulgate reasonable rules and regulations pertaining to the use of the common area, rec facilities, lots, if the governing documents so provide. Don't assume, I won't say what assume means, because we're being recorded. But don't assume that the board has the authority to adopt rules and regulations governing common areas and or lots. You have to look at that. I've seen documents that say that the board's authority to adopt rules only applies to the common area and there's no express authority to adopt rules regarding the lots. I've seen documents that say that rules and regulations must be approved by a certain vote of the owners. So again, not to overstate this, but you really have to look at the governing documents, declaration, articles, and bylaws to determine what vote or what power and authority there is to adopt rules and regulations. Okay. As I mentioned, sometimes they require owner approval. If the board is authorized, to adopt rules regarding the use of a lot, okay, then written notice of any meeting at which the board will consider the adoption or amendment of a rule regarding the use of a lot, as opposed to common area, must be mailed, delivered, or electronically transmitted to the owners and conspicuously posted on the property at least 14 days before the meeting. Remember, you can only electronically transmit notice to those owners who have agreed in writing to receive their notice in that manner. Other rules. Written notice of any meeting at which the board will consider the adoption of amendments to any rule other than those regarding parcel use, such as official record inspection, or rules regarding use of common area facilities, must be conspicuously posted in the community at least 48 hours before the meeting. Again, unless your documents have a different requirement, a greater requirement. The Marketable Record Title Act, otherwise known as MRTA. Basically, a declaration of covenants begins to automatically expire on a lot-by-lot basis 30 years after the deck was recorded. There are some exceptions. At the first board meeting following the annual meeting, not including the organizational meeting, the board is required to consider the desirability of filing a notice to preserve the covenants affecting the community or association from extinguishment under MARTA, and to authorize and direct the appropriate officers to file a preservation. How can they be preserved? They can be preserved for 30 years by timely recording a written notice under 712.06.06, a summary notice under 720.3032, that's as of October 1st, 2018, or an amendment to the declaration, the recording information of the declaration, which references the recording information, that's as of October 1st, 2018. Before that, you could not do it through an amendment. If the documents have not been preserved, then you must undergo revitalization, which requires a unit owner vote, and you got to jump through certain hoops in order to revitalize or revive documents that have been extinguished. Emergency powers. Now, the emergency powers under 723.16, these were amended pretty substantially after, not shockingly, the pandemic back in 2020. So, and the beginning of the end of 2019. So emergency powers were changed. What do they currently say under 723.16? Well, unless specifically prohibited by your documents, the board can exercise emergency powers in response to damage or injury caused by or anticipated in connection with an emergency for which a state of emergency is declared in the area encompassed by the association. By the way, the state of emergency is declared by the governor, okay? Whether that's a hurricane or, as we had under back in 2020, the pandemic, or other things, I guess, could also qualify as a state of emergency, depending on what the governor's office does. These emergency powers are only available to the board for a period of time that is reasonably necessary to protect the health, safety, and welfare of the association and the owners and their family members, tenants, guests, agents, or invitees, and to mitigate further damage, injury, or contagion and make emergency repairs. The contagion was added, as I mentioned, because of the pandemic. These powers, these emergency powers, include the ability to conduct meetings in whole or part by phone, real-time video conference, i.e. Zoom, or similar real-time electronic or video communication after providing notice in a practicable manner as possible, i.e., or that is by publication, radio, U.S. mail, internet, electronic transmission, PSAs, public service announcements, posting on the property, or any other means deemed appropriate by the board. Notice of decisions may also be communicated in that manner. Other emergency powers, the ability to cancel and reschedule meetings, designate assistant officers who are not directors to step into the shoes of an officer if an officer is incapacitated or unavailable, relocate or designate an alternate principal office for the association, enter into agreements with counties and cities to assist the counties and cities with debris removal, implement a disaster or emergency plan before, during, or following the event for which a state of emergency is declared. For example, turning on or shutting off elevators, electricity, water, sewer security systems, or air conditioners. Determine any portion of the common area to be unavailable for entry or occupancy by owners or their family members, tenants, guests, agents, or invitees for the protection of the health, safety, or welfare for their protection based on advice of emergency management officials, public health officials, or licensed professionals retained or otherwise available to the board. Other emergency powers. You can determine whether the common areas can be safely inhabited, accessed, or used, occupied, based on advice, again, of emergency management officials, public health officials, or licensed professionals retained by or otherwise available to the board. You can mitigate further damage or injury or contagion, for example, by removing debris and wet drywall, insulation, carpet, cabinet, or other fixtures within the common area and sanitizing the common area. Levy a special assessments without a vote of the owners, notwithstanding what the governing documents provide, and regardless of whether such authority does not specifically appear in your governing documents, or without the owner's approval to borrow money, and to pledge association assets, which is typically your assessment collection, as collateral to fund emergency repairs and carry out the duties of the association if operating funds are insufficient. That authority to borrow is in addition to an association's general authority to borrow money, subject to any restrictions which are in the governing documents. And notwithstanding the board's emergency power, an association cannot prohibit owners, tenants, guests, agents, or invitees from accessing the common area and facilities for the purpose of ingress and egress from the lot, from the home, when necessary in connection with the sale, lease, or other transfer of a parcel, or the habitability of the parcel, or for the health and safety of such person, unless a governmental order or determination or a public health directive from the CDC has been issued prohibiting such access to the parcel. Any such access is subject to reasonable restrictions adopted by the association. Okay. Next thing is debit cards. And this is something that people are sometimes surprised to hear or understand. An association and its officers and directors and employees cannot, and their agents cannot use a debit card issued in the name of the association or billed directly to the association for the payment of any association expense. A person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not, in quotes, a lawful obligation of the association commits theft. What is a lawful obligation? A lawful obligation of the association is an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or the written budget. So, lesson to learn, don't use a debit card. Litigation authority. What types of litigation or lawsuits can the association enter into or commence with respect to the association? Well, the association can institute, maintain, settle, or appeal actions or hearings in its name on behalf of all members concerning matters of common interest to the members. And that includes, but it's not limited to, the common areas, roof or structural components of a building or other improvement that the association is responsible for, mechanical, electrical, or plumbing elements serving an improvement or building the association is responsible for, representations of a developer pertaining to an existing or proposed commonly used facility, protesting ad valorem, those are basically real estate taxes on the commonly used facilities, and defending an eminent domain lawsuit and bringing an inverse condemnation claim. However, before commencing litigation against any party in the name of the association involving amounts in controversy in excess of $100,000, the association must obtain the affirmative approval of majority of the voting interests at a meeting of the membership at which a quorum has been obtained. So that's a limit on the authority. Architectural control. This is really important because this was big changes or important changes that came into effect July 1 last year. The association must reasonably and equitably apply and enforce on all the owners the architectural and construction improvement standards or other published guidelines and standards authorized by the declaration. If the association denies an owner's request or application for the construction of a structure or other improvement on a parcel, the association must provide written notice to the owner stating with specificity the rule or covenant on which the association relied when denying the request or application and the specific aspect or part of the proposed improvement that does not conform to such rule or covenant. So this is really important. So I'm going to stop here for a second. You have to have either in your covenants or in architectural guidelines or rules which are authorized to be implemented or adopted by the association, specific restrictions or provisions regarding architectural control. And you can't just turn someone down just on some general because we don't like it or it's been disapproved without stating why. Basically, if you're going to deny a alteration or improvement on a parcel, then again, I'm going to repeat this, you must provide written notice to the owner stating with specificity what restriction, what rule, what covenant that the association relied upon to deny that owner, and the specific aspect or part of the improvement that does not conform. So again, you have to tie those two things together. And the last thing I'm going to say here, because I don't think it was mentioned earlier, one of the two types of committees that are open to owners and must be posted like a board meeting is any committee which is authorized under your documents to approve or disapprove architectural control issues regarding an owner's residential lot. So those meetings of the ARB or ACC or whatever you call your architectural control committee, those meetings of those committees are open and must be posted just like a board meeting. An association cannot enforce or adopt a covenant, rule, or guideline that limits or places requirements on the interior of a structure that is not visible from the parcel's frontage or an adjacent parcel, an adjacent common area, or a community golf course. You cannot require the review and approval of plans and specifications for a central AC system, refrigeration, heating, or ventilating system by the association if the system is not visible from the parcel's frontage, an adjacent parcel, an adjacent common area, or community golf course, and it is substantially similar to a system that is approved or recommended by the association. This next one is kind of interesting. Stuff that people leave on their lot or leave on their parcel. And regardless of any covenant, restriction, bylaw, rules, or requirements of an association, and unless prohibited by general law or local ordinance, the association cannot or may not restrict owners or their tenants from installing, displaying, or storing any item on a lot, on a parcel, which are not visible from the parcel's frontage or an adjacent parcel or an adjacent common area or a community golf course, including, but without limitation, artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. So if it can't be seen, they can leave it there. This is also new on hurricane protection, also pretty important. It's also effective July 1 of last year. An HOA, the association, must adopt hurricane protection specifications for each structure or other improvement on a parcel governed by the association. Hurricane protection includes, without limit, roof systems, permanent fixed storm shutters, roll-down track storm shutters, impact-resistant windows and doors, polycarbonate panels, reinforced garage doors, erosion controls, exterior fixed generator, fuel storage tanks, and other hurricane protection products used to preserve and protect the structures or improvements. These specifications must comply with the applicable building code. However, you can include color and style of the hurricane products and any other factor deemed relevant by the board. So as long as they comply with applicable code, the association can also, the board can also impose limitations or restrictions on color and style and other factors. The association cannot deny an application for the installation, enhancement, or replacement of hurricane protection by an owner which conforms to those hurricane specifications or conforms to the hurricane protection specifications adopted by the association. However, the association may require an owner to adhere to an existing unified building scheme regarding the exterior appearance of the structure or other improvement. So if there's a unified scheme of, all the roofs are a certain tile, certain style, or all the windows are a certain style, you can enforce that style as long as, hopefully it still complies with current building code. So you can require that the uniform appearance of the community stays intact. And vehicle restrictions, this got a lot of publicity, I know, or a lot of interest when they changed this law, which basically says that associations of government documents cannot prohibit an owner, tenant, guest, or invitee from parking his or her personal vehicle, including a pickup truck, which I know caused a lot of heartburn, in the owner's driveway or in any other area at which the owner's tenant, guest, or invitee has a right to park, as governed by state, county, and municipal regulations. An owner, tenant, guest, or invitee, you can't prohibit an owner, guest, or invitee from parking his or her work vehicle, regardless of any official insignia or visible designation, which is not a commercial motor vehicle as defined in section 320.01. So basically, you have to allow, or you cannot prohibit an owner's or their guests, invitees' personal vehicle, and you cannot prohibit their work vehicle, unless it's a commercial vehicle. I'll get that in a second. You cannot prohibit an owner from operating a vehicle that is not a commercial vehicle, as defined in 320.01, and conforms with state laws on public roads or rights of way or the owner's parcel. Now, I'm going to stop here for 1 second. We talked a little bit ago about Kaufman language and how new laws affect current documents. In our opinion, and I think most practitioners who do what we do, okay, if a declaration or rules prohibited, let's say, pickup trucks before this law was enacted and became effective last year, and those documents did not have what we call Kaufman language, they did not incorporate future amendments to the act with respect to that declaration or to that property, and in our opinion, those pre-existing pickup truck or other vehicle restrictions are still enforceable. In other words, that the new law didn't negate them because it didn't apply retroactively to the pre-existing covenant. If your documents did, though, have Kaufman type language, or it did incorporate future changes to Chapter 720, then those laws would apply, including these vehicle restrictions. So that's just an important point that I wanted to make. An association's governing documents also cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on the owner's parcel solely because the contractor or worker is not on a preferred list of the association. You cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker onto his or her parcel or lot solely because the contractor does not have a professional or occupational license. So in other words, the association may not require a contractor or worker to present or prove of a professional or an occupational license in order to be allowed entry onto a property owner's lot or parcel. Now we're going to talk about budgets and reserves. Budgets. Every year, the association must prepare an annual budget that reflects the estimated revenues and expenses for the upcoming fiscal year and the estimated surplus or deficit as of the end of the current fiscal year. Now, these budgets must set out separately all fees or charges to be paid for recreational amenities, whether owned by the association or a developer or another person, if that's applicable to your association. And a budget basically has two components, operating and reserves, okay? And as a practice tip on there, typically you use last year's budget as a template, for your next year's budget. That doesn't mean you copy last year's budget. You still have to budget based on your anticipated expenses. So you can't just, use last year's and say, okay, we're going to adopt the same budget. There you just work off of last year's expenses when you're preparing your next year's budget. Now, money in the operating side of the budget are not restricted to any purpose, and they can be moved around and used for anything that the board wants, basically, unless something in your government documents restricts that. Operating expenses are your day-to-day expenses, your day-to-day recurring expenses to operate and administer the association. They must be listed by account and classification and project the total proposed annual expenditure in each classification. Examples of things that are on the operating side of the budget: administrative and management fees, maintenance and repair of the common area. That's day-to-day maintenance repair, not necessarily reserve expenditures. We'll talk about that in a minute. If you pay any rent for recreational and other commonly used facilities, any taxes incurred on property owned or leased by the association, insurance expenses, and professional fees, such as accounting fees and attorney's fees. Now, reserves. I'm going to skew into condo here a little bit because I want to make a compare and contrast because they're very different. And I think some people think that the condo laws apply to HOAs on reserves, and they don't. So in addition to operating expenses, the budget may, and it's a may, include reserve accounts for capital expenditures and deferred maintenance, for which the association is responsible. A capital expenditure means any expenditure of funds for the purchase or replacement of an asset whose useful life is greater than 1 year, or repair to an asset which will extend the useful life for a period of greater than 1 year. Deferred maintenance means any maintenance repair that will be performed less frequently than yearly and will result in maintaining the useful life of an asset. Examples of these type of expenditures: resurfacing of pavement, repair improvements to common area or association property, or sidewalk or other type of improvements like that, or repairs. Now, I'm going to take a moment here. In a condominium, I'm not trying to confuse people, but I just want to make sure you understand. In a condominium, associations must budget for reserves, and they must budget for certain reserves every year. Sometimes they can be waived, not all of them. Sometimes they can be reduced, but an HOA doesn't have that. Okay. In an HOA, there is no mandated statutory reserves unless the reserves are created upon the affirmative approval of majority of the total voting interest of the association. In other words, so the owners are voting in the requirement to maintain reserves. Upon approval by the membership, again, not the board, upon approval by the membership, the board must then include the required reserve accounts in the budget of the next fiscal year, following year that the membership vote was taken, in each year thereafter. Once established, statutory reserves, and again, for an HOA, that means reserves that are approved and voted in by the owners, must be funded, maintained, or waived in the manner provided by the statute. That is, statutory reserves may be waived or partially funded only upon a vote of the majority of the members present in a meeting in which a quorum is present. Reserves created any other way are not subject to these restrictions. So in other words, board-made reserves, if the board creates reserves, those are not subject to all the statutory limitations, and they can be created, they can be spent, they can be literally uncreated by the board. All right. So it's very, very different than a condominium. I just wanted to make that clear. Now, if you have statutory reserves, then again, voted in or approved by the membership, then the amount to be reserved is based upon the estimated remaining useful life, an estimated replacement cost, or deferred maintenance expense for each reserve item. The association may adjust reserve annually to take into account any changes in the estimated estimate of the cost of or the useful life of a reserve item. And the funding formula for these statutory reserves must be based on a separate analysis of each of the required assets, or a pooled analysis of 2 or more of the assets. Again, that's further defined by the statute. Unless the association maintains a pooled account. Now, what's a pooled account? A pooled account is where you have 2 or more assets or 2 or more things within that reserve account, as opposed to a line item individual reserve account. Unless the association maintains a pooled reserve, the reserve schedule should include each reserve account for capital expenditures and deferred maintenance or replacement as a separate line item with the following minimum disclosure: total estimated useful life of the asset, estimated remaining useful life of the asset, estimated replacement cost or deferred maintenance expense of the asset, and estimated fund balance as of the beginning of the period for which the budget will be in effect. Changing the use and talking about pooled reserves a little more. Using reserves for other purposes. Okay. For statutory reserves, reserve funds and any interest accruing thereon must remain in the reserve account and can only be used for unauthorized reserve expenditures unless they're used for other purposes as approved in advance by a majority vote. So if you have statutory reserves, they have to be used for the purpose for which they've been designated, unless you get the prior approval of majority vote of the owners at which a quorum is present. Not a majority of all, but a majority at a meeting at which a quorum is present. But what about pooled reserves? An association may also establish a pooled reserve instead of or in addition to individual line item reserve accounts. If the association establishes a pooled account for 2 or more reserve items, funds may be drawn from this account only to pay for any of the items that are in the pool. So in a pool, if you have 2 or 3 items in a pool, you can use those funds for anything that's in the pool. If there's line item, only for that item. And again, I know I repeat myself 10 times here today. This refers to a statutory type reserve, not the non-statutory reserve. As I mentioned before, real quickly, the difference between individual reserve account and pooled is that instead of each individual reserve item having its own fund balance for a particular item in a pool, it's a fund balance to be used for anything that's in that pool. Okay, waiving, reducing, and terminating statutory reserves. After 1 or more statutory reserves are created or established in accordance with the statute, the proposed budget must include the statutorily defined reserves, and the association must fund those reserves unless the majority of the voting interest present at a duly called meeting, at which you have a quorum established, votes to waive the funding or partially fund the funding, partially fund those reserves. The vote to waive or partially fund is only applicable for the budget year that the vote was taken, for 1 fiscal budget year. Whether to submit a vote to the membership to waive or partially fund statutory reserves is within the discretion of the board and is not required. So if the board wants to keep maintaining those statutory reserves and not have the owners vote to waive or partially fund them, they don't have to. How about terminating the reserves? Reserve accounts established pursuant to statute may be terminated, in other words, ended, upon the vote of a majority of the total voting interest, not a majority of the quorum, majority of the total voting interest. Upon such approval, the terminated reserve accounts must be removed from the budget. Notice and adoption of the budget. Interestingly, the governing documents, you have to review them to see what budget adoption procedure they have. I'm going to skew into condo for a second here, just as a compare and contrast. Condominium Act expressly indicates how a board or how an association must adopt their budget. HOA Act does not. Okay. For an HOA, you have to look at your governing documents for any specific budget meeting notice and adoption procedure or requirement. Again, because the HOA Act doesn't have a specific procedure. The only thing the HOA Act says is that if you're going to be adopting, anything regarding the adoption of assessments or concerning assessments, that must be expressly noticed or expressly set forth on the agenda for the meeting. And then unless your documents have a greater period of time, it's a 48-hour posted notice to adopt the budget. But check your documents. Again, unless the documents require the board to provide a copy of the proposed budget to all the owners before the meeting at which it will be adopted, you're not required to do so. However, just as a practical matter, it's probably good business or good business sense to provide them a copy of the budget. Obviously, if your documents say you have to, then you have to. If it's silent, you don't have to, but it's a good idea to do it anyway. After the budget's been adopted, though, you do have to provide each member a copy of the budget or written notice that a copy is available upon written request at no charge. If requested by an owner, then you have to provide a copy to the owner within the time frame for inspection of records, which is, as we mentioned before, 10 business days from receipt of the request. Under the new law, for those associations required to have a website or an app, if you have 100 or more parcels, then you have to post your budget, a copy of your current budget on the app, as well as a copy of a budget you're going to potentially approve at the annual meeting. Now we're going to move into assessments and foreclosures or collections. So I think we mentioned this earlier. We're going to mention it again because it is important. Written notice of any board meeting at which a special assessment will be considered for adoption by the board must be mailed, delivered, or electronically transmitted to those owners who have agreed to that. And it must be conspicuously posted on the property at least 14 days before the meeting. So sent to the owners and posted 14 days in advance that board meeting notice. That notice must include a statement that a special assessment will be considered to be adopted, and the nature of the assessment and the estimated cost or amount of the assessment. If levied or if approved, then the association should send written notice to the owners of the special assessment that it's been adopted and provide the owners a reasonable period of time. Now that time may be in your documents. If not, make it a reasonable time within which the assessment is due or must be paid. A special assessment that has not been paid by an owner can be collected just like a regular assessment, so it's subject to the same lien and foreclosure process. Requirement to provide an accounting, also a new provision as of last year. An owner may make a written request to the board for a detailed accounting for any amounts that he or she owes related to their lot. And the board must provide that within 15 business days after receipt of the owner's request. After the owner makes that request, he or she may not request another detailed accounting for at least 90 calendar days, assuming the association responded properly to the request. If they did, then the owner is precluded from making another accounting request for 90 days. Failure by the board to respond within 15 business days to a written request for a detailed accounting constitutes a complete waiver of any outstanding fines of the person who requested such accounting, which are more than 30 days past due. So it's not a waiver of any assessments that are due, but failure to provide the accounting timely is a waiver of any fines which may be due. Interest. Okay. You're authorized and able to charge interest pursuant to the provisions of your documents if they set forth the interest amount. If the documents are silent or no rate is provided, then you can charge interest at 18%, which is the current statutory limit. Okay. However, notwithstanding what your documents say, you cannot charge compound interest on assessments or installments of assessments. Late fees. There is no right to charge late fees unless it's provided by your documents. So you can charge an administrative late fee, currently not to exceed the greater of $25 or 5% of the amount of the installment that's delinquent, if permitted by your documents. Now, you can't charge interest on interest or interest on late fees. And if your documents have a lower amount, for example, if your documents say your late fee is $10 or $15, then you're limited to that amount. But remember, there's no authority to charge late fees unless authorized by the declaration or the bylaws. Now, you're also entitled to collect attorney's fees and costs incurred, but you have to jump through the hoop first of providing them a notice of late assessment, which we're going to talk about in a second. Application of payments. This is very important. Any payment received by an association must be applied statutorily first to any interest accrued, then to any late fee, assuming you have authority to charge late fee, then to any costs and attorney's fees incurred, and then to delinquent assessment. So that's how a payment must be applied in that order or in that priority. You cannot require payment of attorney's fees related to a past due assessment without first delivering. This is pretty new. This was a couple of years ago. So before you can charge an owner attorney's fees related to a delinquency, you have to give them written notice of late assessment to the owner, which specifies the amount owed and provides the owner 30 days to pay. There's a statutory form of this notice of late assessment. It's set forth in section 720.30853D. That notice of late assessment must be sent by first-class mail to the owner at their address as reflected in the association's records. And if that is not the lot address, then it must also be sent to the owner at the lot address. So if an owner has an official address up north or somewhere else, and it's not the lot, then this notice of late assessment must be sent to the owner at that address as well as the lot address, okay? There's a rebuttable presumption of the association mailed the notice in accordance with the statute if a board member, officer or agent, or a licensed manager provides a sworn affidavit attesting that the notice was mailed in accordance with the statute. Now, again, this is a precondition, and this notice of late assessment, the form is set forth in the statute. So don't create your own form or don't make up your own form. If this notice of late assessment is not sent out to the owner, then the association will be precluded from collecting attorney's fees from that owner related to the collection of the assessments. Now, let's say that the notice of late assessment was sent out, the owner still hasn't paid. Now you want to collect the assessments because the owner hasn't paid pursuant to the notice of late assessment. Then typically the matter will be turned over to your attorneys for collection. Now, in that case, the association has a lien for all unpaid assessments. They must provide the owner with a 45-day notice of intent to file the claim of lien. That notice goes out by certified mail, return receipt requested, okay? So the notice of late assessment is a 30-day notice, then the matter gets turned over. The attorney then does a 45-day notice of intent to file a lien. Attorney's fees now can be included in that notice. Let's say the 45-day notice goes out, owner still hasn't paid. Then the board can start a foreclosure action, but the lien gets recorded after that first 45-day notice. The second 45-day notice goes out to the owner with a copy of the lien, okay? And that 45-day notice basically says that you have to pay these amounts. This lien's been recorded. Here's a copy of the lien. And if you don't pay in 45 days, the association can foreclose. So long story short, before an association can get to foreclosure, the minimum time period is a 30-day notice of late assessment, the initial 45-day notice of intent to file a lien, and then a copy of the lien gets recorded, and another 45-day notice gets sent out saying, here is your lien. If you don't pay in 45 days, there's going to be foreclosure. So just keep that in mind. 30 plus 45 plus 45 is the minimum time before a foreclosure action gets started. What about first mortgagees? What do they pay when they foreclose and take title? Well, it depends. But basically, the liability of a first mortgagee or its successor assigned who acquires title, again, this is first mortgagee only, who acquires title to a lot by foreclosure or by deed in lieu of foreclosure for unpaid assessments that became due before the acquisition of title by the mortgagee is the lesser of the lot's unpaid common expenses and periodic or special assessments that accrued or came due during a 12-month period immediately before the acquisition of title, okay, or 1% of the original mortgage debt. Again, whichever is less, that is the limit of the mortgagee's obligation to pay those past due assessments. Now, that limitation or safe harbor on what they owe only applies if the first mortgagee named the association as a defendant when the first mortgagee was starting their foreclosure action. What about a third party? So a third party, anybody, bids on a foreclosure. That person or that party, unless the documents exclude them, has joint and several liability for the past due assessments. Okay, so they're gonna have to pay if they bid on that first mortgagee's foreclosure. However, if an association forecloses and the association acquires title and then the lender forecloses, so the association took title subject to that mortgage out there and held on to it, and a third party then bids on the mortgagee, the first mortgagee foreclosure, that third party bidder is not liable for assessments that came due while the association owned the lot. Financial reporting. So every year you're required to do a financial report, end of year financial report. That must be done within 90 days after the end of the fiscal year or annually on such date that's provided in your bylaws. Within 21 days after that annual financial report is completed or received from the third party, but no later than 120 days after the end of the fiscal year or other date that's in the bylaws, you must provide each owner with a copy of the report or written notice that a copy is available at no charge. Now, what kind of report do you have to do? Well, it depends on your documents and it depends on your total annual revenue for the year for which the report's being prepared. They're based on annual revenue, as I mentioned. So if your annual revenue is less than $150,000 for that year, it's a report of cash receipts and expenditures. If it's more than $150,000 but less than $300,000, it's a compilation. If it's $300,000 but less than $500,000, it's a review. And if it's $500,000 or more in revenue, it's an audit. However, I'm just going to mention this. If your governing documents require you to do an audit or some level of reporting above what your revenue requires, you have to do that level of reporting required by your documents. Now, as of July 20th through July 1st of 2024, regardless of your revenues, if you have 1,000 lots or more, you have to do an audit. So notwithstanding your revenues, 1,000 lot association or more must prepare an audit. Now, if the owners petition the board, 20% of them, and they want a greater level of reporting, then you have to hold a meeting of the members within 30 days after receipt of that petition to raise the level of the reporting. Again, you can raise it to a compilation, review, or audit if you're otherwise required to do a cash receipts and expenditures, a review or an audit if you're required to do a compilation, or an audit if you're required to do any of the 3 lesser reviews. Personally, I've never seen an association receive this type of petition, but I guess it is possible. A copy of that report also must be provided to the owners within 90 days of the meeting or the end of the fiscal year, whichever occurs later. The board must amend the budget or adopt a special assessment to pay for a financial report, regardless of any provision of the contract in the documents. Now, what you see more typically is lowering the level of the report as opposed to raising. Again, so unless your documents require a certain level of reporting in which you can't lower it, if approved by a majority of the voting interest of the owners present at a duly called meeting, that you have a quorum established, you can prepare a lesser report. So cash receipts rather than a compilation, review, or audit, or cash receipts or compilation rather than a review or an audit, or cash receipts, compilation, or a review rather than an audit. But if you're going to vote, if your owners are going to vote to reduce that reporting level, you cannot prepare a financial statement at a lower reporting level for consecutive fiscal years. So you can only basically waive 1 year or lower it 1 year. Then you have to go back to what you're supposed to do the next year. You can't lower the reporting 2 years in a row. Required reserve disclosures in your financial report. So depending on the type, and I'm not going to go through this whole thing, and you guys can get this when you get it. Basically, depending on the type of reserves the association is maintaining or not maintaining, then the financial report has to have this bold capital language regarding reserves, basically telling owners that the association is not maintaining reserves or is maintaining non-statutory reserves. And this is the disclosure language. Contracts and bidding, and this is something that's that you're all going to have to comply with, and hopefully you all are. A contract must be in writing if it cannot be performed within 1 year for the purchase or lease of materials, and if it's a service type contract. I advise all contracts to be in writing, quite frankly, because you need that certainty between yourself and the other contracting party. All written contracts entered into by association for the operation, maintenance, or management of the association property should specify. Okay, and these are things, practice tips, and contracts, quite frankly, I think it's always advisable. I don't like to shill for lawyers, quite frankly, but I think it's always advisable to have your attorneys review your contracts before you sign them. There are pitfalls that you may not be aware of, but things that should be in the contract are the obligations. What's the party required to do? With respect to maintenance or management services, the cost for each of the services, or the cost of the contract, the frequency that they will be performed, or if it's a construction contract, the commencement time and the completion time, and the minimum number of personnel to be employed for the purpose of providing the services to the association. But again, Contracts can be pretty complex. Just as an aside, there is no inherent right to terminate a contract if you're not happy. Contracts are only terminated pursuant to their terms or by statute. So don't assume you have a 30-day right to terminate a contract, because you probably don't, unless the contract has termination language in it. And if you do terminate it, you have to adhere to the termination provisions of the contract. That's not part of the slides, but just an aside. As far as bidding, if the aggregate cost of the contract, the goods or services, is more than 10% of your total budget, including any reserves, you must obtain competitive bids. That's bids plural. That's not 3 or 4 or 5. If your if your HOA documents require a minimum number of bids, then you have to comply with that. Otherwise, it's just 2 or more plural bids. You're not required to accept the lowest bid. And oftentimes you don't want to accept the lowest bid, but sometimes you are. But you're not required to accept the lowest bid. In an emergency, you're not required to obtain competitive bids for projects or services. Again, but it has to be a bona fide emergency. A bona fide emergency. Also, if there's only one provider for that particular product or service in the county in which you're located, then you don't have to get bids. So if there's only one provider for those goods or for that service, there's no competitive bids. Also, contracts entered into before October 1 of 2004, and any renewal of those contracts are not subject to the bid requirements. Again, that's over 20 years ago. Now, there are certain things that are exempt from bidding. This says exempt. Doesn't mean you can't get bids, but you're not required to get bids. So employees, the attorney for the association, the accountant, the architect, the community association manager. If by competitive bid, it may be made up for 3 years. Engineers and landscape architects. However, these contracts must be in writing. And as I said, you can still obtain bids. You're just not required to get bids. Estoppels, and this is very important. Estoppel certificates are something that are requested from the association, usually in connection with the sale or conveyance of a lot. Estoppel is basically a word that means reliance, if you want to translate what estoppel really means. So within 10 business days of receiving a written or electronic request for an estoppel certificate from an owner, a mortgagee, or their designees, the association must issue the estoppel certificate. Again, usually this is in connection with the sale of a lot. You must designate on your website, if you have a website, required to have a website, a person or entity with a street or email address for receipt of the estoppel certificate requests. They must be prepared by a board member, authorized agent, or authorized representative of the association, including any authorized agent, representative, or employee of your management company. The estoppel certificates must be provided by hand delivery, regular mail, or email on the date of issuance. Interestingly, they cannot be provided by facsimile. So it's hand mail, regular mail, or email. They must be signed by an authorized or authorized agent of the association. What goes in the estoppel? Okay. The date of issuance. That is important. The name of the owner of the particular lot as reflected in the books and records of the association. The property designation and address. Any parking or garage space number reflected in the books and records. If the account is delinquent for that particular lot, then you have to include the attorney's name and contact information that delinquency is being handled by, has been turned over to. You have to include the fee for the preparation and delivery of the estoppel. We'll get to that in a second. And the name of the requesting party. Now, here's the real meat that goes into the estoppel. It's the assessment information and violation information. So the assessment information, you must include the amount of the regular periodic assessment, whether that's monthly or quarterly, or perhaps annually, levied against the property and the frequency of assessment, date that the regular periodic assessment is paid through, so what is it current through, date of the next installment of the regular periodic assessment that is due and the amount due, itemize a list of all assessments, special assessments, and other monies owed on the date of issuance to the association, what is owed to the association by the owner for that lot, for that property, and an itemized list of any additional assessments, special assessments, and other monies that are scheduled to become due for each day after the date of issuance for the effective period of the estoppel. In 1 second, we'll explain it. The effective period of the estoppel is either 30 or 35 days, depending on how it's issued. In calculating the amounts that are scheduled to become due, the association may assume that any delinquent amounts will remain delinquent during the effective period of the estoppel certificate. So, the other information that's included in the estoppel is whether there's a capital contribution fee, resale fee, transfer fee, or other fee due, and if so, the amount and type of the fee. Whether there was any open violation of a rule or regulation noticed previously to the owner of the property in the official records. This is important because if there's an open violation of a rule or regulation which you have written to the current owner and this lot's being sold, and you don't include that on the estoppel, then the new owner can say, hey, you didn't include it. I'm relying on your silence. So there is no violation. So you don't want to waive a violation. If there's an open violation that you've written notice to the current owner, you got to include that. I always include, or tell my client to attach a copy of the letter that was sent to the prior owner or letters about that open violation. Anyway, number 3, whether the rules and regulations applicable to the property or the covenants actually require approval of the board for the transfer, and if so, whether or not that board has approved the transfer of the property to the new owner or the new buyer. Where there is a right of first refusal provided to the members or the association in the covenants, and if so, whether or not the members or the association exercise that right of first refusal. A list of contact information for all other associations for which the owner is a member. So if this is a sub-association and there's a master association that the owner had to be a member of, you have to identify that master association and the contact information for it. And also contact information for all insurance maintained by the association. That would typically be the association's insurance agent, name and address. Now, you can charge a fee for these estoppels. If the lot is current, it's not delinquent, then you can charge a reasonable fee not to exceed $250. Again, if that lot is not delinquent. If it's delinquent, you can charge an additional fee not exceeding $150. If it's delinquent. Let's say they want an expedited estoppel. They have a settlement or they have a closing and it's coming up right away, and they want you to expedite this. In other words, they want it faster than the 10 business days. If an expedited estoppel certificate is requested and delivered within 3 business days, then you can charge an additional $100 for the estoppel. In order to charge the fee, any of those fees, the authority to do so must be established by a written resolution adopted by the board or provided by a written management, bookkeeping, or maintenance contract. Late delivery. If you fail to deliver the estoppel certificate within 10 business days of receipt of the request, then the fee is waived and you can't be charged. What about reimbursement? Under certain circumstances, it has to be reimbursed. If the certificate is requested in conjunction with the sale or mortgage of a lot, but the closing does not occur, and no later than 30 days after the closing date for which the certificate was sought, the preparer receives a written request accompanied by documentation that the sale did not occur from the payor that was not the owner, then the fee must be refunded to that payor within 30 days, whether that was the buyer or the mortgagee or whoever. We mentioned what is the effective period. Well, here's the effective period. Estoppel certificates delivered by hand delivery or email are effective for 30 days. Estoppel certificates sent by regular mail, hard copy mail, are effective for 35 days. Remember, that's important because you have to include in the estoppel any monies coming due to the association for that effective period. So for the next 30 or 35 days. If additional information or a mistake is related, or a mistake related to the estoppel certificate becomes known. So if there's an oops and there's a mistake made, and you become aware of it within the effective period, an amended estoppel may be delivered and become effective if a sale or refinancing has not been completed. So in other words, if you sent out an estoppel, you're aware of an oops, you're aware of a mistake, the closing hasn't occurred, you're still within the effective period, you can send an amended one. You can't charge for the amended estoppel, but you can send it out. It's also good for a new 30 or 35 days. Now, the bottom there is extremely important, the language that's in red or orange or whatever color that is. An association waives the right to collect any monies owed in excess of the amount specified in the estoppel certificate from any person who in good faith relies upon the estoppel certificate and from the person's successor in the signs. So, if a lot's being sold, the lot is delinquent or owes you money, or there is a special assessment coming due within the effective period, and that is not either or both are not identified in the estoppel, then the new owner, he or she doesn't have to pay it, neither any other successive owner. So it's very important that these estoppel certificates accurately include the assessment information that was in a few slides ago regarding the current amounts of assessment and delinquencies that are owed and assessments coming due within the effective period and monies coming due within the effective period. Covenant enforcement. As I'm sure many of you have been involved with, the association is charged with the responsibility of uniformly enforcing your governing documents with respect to the association's covenants, restrictions, rules, and regulations. These can be anything. We talked about architectural control before. You can have restrictions or rules regarding pets and leasing and parking and all sorts of things that are set forth in your documents. What's a nuisance, new nuisance conduct. Now, the failure to enforce them in a timely manner may result in you waiving or forfeiting enforcement, or if you enforce them inconsistently, not consistently, then that may cause selective enforcement to be raised as an affirmative defense, that you're not uniformly enforcing the covenants or the rules. And that can cause an owner to argue or to raise the affirmative defense of selective enforcement. Now, the first step when you're enforcing your rules or covenants is to provide the owner, the violating owner, a notice of the violation, including a statement of the violation, what's being violated, and an opportunity to cure, if applicable. If voluntary conveyance is not achieved, in other words, if they don't comply, then you have, there's certain remedies available, including fines, suspensions of use rights, suspension of voting rights. That's for monetary delinquencies, and even that's limited to a degree. Self-help, if your documents authorize the association to basically correct the violation itself. And then there's mandatory pre-suit mediation followed by litigation, because pre-suit mediation for most of this actions is a precondition of litigation. Fines and use suspensions. The association has the authority to fine and suspend use rights for failure to comply with the documents, but you have to follow certain procedures in order to fine or impose a use suspension. Basically, the board first levies the fine or the suspension at a properly noticed board meeting. So that's not first done by the committee, but the board initially levies the fine or the use right suspension at a properly noticed board meeting, and it should be on the agenda for that board meeting. Then the board, assuming the fine or the use suspension has been imposed by the board, then the board has to give the violating party a 14-day notice of an opportunity for a hearing regarding the violation. And that notice must describe the alleged violation. It must include the specific action to cure it, if applicable, if it can be cured, and the date and location of the hearing and access information if the hearing is going to be held telephonically or by other electronic means. The hearing itself must be held within 90 days after issuance of that notice. And it must be before a committee. It's at least 3 people. And it's very important that that committee not be comprised of any officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. The role of the committee is limited to determining by majority vote whether to confirm or reject the fine or the use right suspension. So the committee is a little appellate body in essence. The board imposes the fine, the board imposes the suspension, And the entire role of the committee is to affirm or reject that fine or that suspension. If the committee does not confirm it, does not approve it, then the fine or suspension cannot be imposed. The board cannot overrule the committee, in other words. The committee can overrule the board, but the board cannot overrule the committee. The committee may hold a hearing by telephone or other electronic means, and the owner has the right to attend the hearing by telephone or other electronic means. Excuse me. Within 7 days after the hearing, the committee must mail or email written notice to the violating party of their findings related to the violation, including the applicable fine or suspension, and how the violation can be cured, if it can be cured, and the date by which the fine must be paid. If the violation is cured, either before the hearing or in the manner specified in the notice, in the hearing notice, or in the notice from the committee, the fine cannot be imposed. So basically, you got to remember that what you're looking for is compliance, not so much collecting a fine. The fine is a means for compliance. So again, if the violation is cured before the hearing or in the manner in the hearing notice, or even when the committee sends out their findings and they indicate how it can be cured, if the matter is cured, then there's no fine or suspension. If a violation is not cured and the fine levied by the board has been approved by the committee, by the majority vote of the committee, then the committee must set a date by which the fine must be paid, and that date must be at least 30 days after delivery of the notice of the findings. So remember that finding notice goes out within 7 days of the hearing, assuming the violation is not cured or it can't be cured, then the fine itself, the due date, is at least 30 days after delivery of the committee's notice. Attorney's fees and costs may not be awarded against the owner based on actions taken by the board before the date set for the fine to be paid. If a violation and the fine levied by the board is approved by the committee and the violation is not cured, the fine is not paid, per the committee notice, per their findings, then reasonable attorney's fees and costs may be awarded to the association. How much can you fine? Well, that's limited unless your documents provide otherwise. So a fine for an individual violation cannot exceed $100 unless otherwise provided by your governing documents. You can also levy a fine on a continuing basis with a single notice, an opportunity for a hearing for a continuing violation, but that continuing violation fine cannot exceed $1,000 in the aggregate, again, unless your documents provide otherwise, allow for a greater fine. A fine of $1,000 or more may become a lien against the lot and collected through the lien and foreclosure process if the authority to do so is provided in the declaration. As an aside, by the way, in a condominium association, they cannot lien for a fine. In an HOA, you can lien for fines of $1,000 or more if your documents provide that it's subject to your lien and foreclosure. How about a use right suspension? A suspension of the right to use the common areas and facilities does not apply to that portion of the common area used to provide access or utility service to the lot and cannot prohibit an owner or tenant from having access either by vehicle or pedestrian to and from their lot, and you cannot suspend their right to park. A suspension does apply to an owner, and if applicable, the owner's tenants, guests, or invitees, even if the violation resulting in the suspension arose from less than multiple lots owned by the member. There are certain things under the new law you cannot fine for, okay? The first one of those is leaving your garbage receptacle or your trash can, trash receptacle container at the curb or the end of the driveway if it's within 24 hours before or after the designated date for garbage collection. Also, you cannot fine for leaving holiday decorations or lights on a structure or other improvement longer than indicated in the governing documents unless they're left up for more than a week after the association provides notice of the violation of the governing documents. You can suspend an owner's use rights if the owner is more than 90 days delinquent in any monetary obligation, that would include a fine, due to the association through board action. So a suspension for a delinquency of more than 90 days is not subject to the approval of the fining or suspension committee, or whatever you want to call your committee, but that's done at a board at a properly noticed and convened board meeting. For that suspension to take effect, after the board adopts it or approves it, written notice must be mailed, hand-delivered, or emailed. Again, email requires written consent of the owner, to the owner, and if applicable, to the occupant, licensee, or invitee of the owner's lot. A suspension of use rights to use the common area does not apply, as I mentioned before. That portion of the common area is used to provide access or utility service to the lot. You can't prohibit vehicular or pedestrian ingress and egress, ingress to and egress from the lot, and the right to park cannot be suspended. It also applies, that type of suspension, to a member, and if appropriate, the owners or members' tenants, guests, or invitees. Again, even if it's arose from less than all of multiple lots owned by the owner. That type of suspension will terminate upon the full payment of the delinquency on which it was based.
All right, folks, we're in the home stretch. Before Peter gets to the next slide, if you haven't already enabled your chat feature, not to be confused with the Q&A, that's totally different. Hit the chat button simply so it appears. It will say it is disabled for you. Don't worry. We can still send stuff your way. I've already placed the evaluation link in the chat once, and I will do it again in about a minute. Peter, back to you for the last few slides.
Okay. I wasn't watching the clock, as usual.
We're on the home stretch.
Okay. Okay, we mentioned that one. Okay. Voting suspension, real quickly. You can also suspend an owner's right to vote if they're more than 90 days delinquent. However, pursuant to appellate case law, voting rights are a vested right. The ability to suspend an owner's right, the ability to suspend an owner's voting right for being delinquent came into the statute in July of 2011. So if you have a declaration recorded before that date, okay, the right to suspend someone's right to vote is not effective unless that declaration has that Kaufman language that we mentioned before, or you amend the declaration to expressly allow suspension of voting rights. If you have a declaration that's post July 1, 2011, when it was recorded, then you will have that ability, without the Kaufman language. So, but in our view, that right doesn't apply to a pre-existing declaration. Anyway, it's the same type of thing. It has to be done in a board meeting with the same notices to the owner about the suspension of voting rights. Precinct mediation. Basically, most disputes, not all, between association and owner are subject to what's known as precinct mediation. And those things include changing the use of a parcel or to the common area, or use of or changes to, amendments to the documents, meetings of the board and meetings of the committees, membership meetings, access to records, covenant enforcement. Any of these things, if in order to get to court, first you have to go through pre-suit mediation. Okay. And we're going to talk about that in 1 second. It's a statutory process. Pre-suit mediation does not apply to collection of your assessments, enforcement of a prior mediation agreement, eviction or removal of a tenant, breach of fiduciary duty with respect to a director, and recall. So what happens before you can go to court or file a lawsuit against an owner? Let's say an owner has an architectural control violation, okay, something like that. You first have to notify the owner with a special letter called a demand or statutory demand or statutory offer of pre-suit mediation. That offer of pre-suit mediation must comply with the form of that set forth in section 720.3111 or 311. That letter or that statutory offer of pre-suit mediation basically sets forth 5 mediators that the owner must select one of them to go to mediation. He or she must respond to that letter within 20 days, selecting one of those mediators and agreeing to go to pre-suit mediation. The mediation must be held within 90 days of the date of that initial letter. The parties are required to share the cost of the pre-suit mediation unless they otherwise agree. Okay. The pre-suit mediation is privileged and confidential, to the same extent that a court-ordered one is. By the way, mediation is not arbitration. Mediation is a settlement conference, in essence. It means the parties are agreeing to meet, and if they settle the case, great. If they don't settle the case, well, then it's an impasse. And then the one that brought the offer of pre-suit mediation can then file suit. Persons who are not parties to it cannot attend the pre-suit mediation without the consent of all the parties, except for attorneys representing either party. When mediation is attended by a quorum of the board, it's not a board meeting for purpose of notice. Okay. Generally speaking, you don't have a quorum of the board there. Usually you have one board member who is authorized to enter into a settlement on behalf of the board. But if you have a quorum of board member there, it's still not a board meeting that gets noticed. You can have an impasse. What's an impasse? An impasse is if at the mediation, the parties can't agree. They can't settle. That's an impasse. Impasse also occurs if a party fails to respond. A party fails to agree upon a mediator. Any party fails to pay their share to the mediator. Any party fails to appear at the scheduled mediation without the approval of the mediator, or the mediation cannot be scheduled and done within 90 days after the demand was filed. In all those instances, then the moving party can pursue or can proceed to court. If someone has failed to participate in pre-suit mediation, either by not responding or failing to appear, then even if they win any litigation that arises after that, they're not entitled to recover their attorney's fees. If an impasse is reached and both parties participated, and then the lawsuit is filed, the prevailing party is entitled to recover their fees both from the litigation and from the mediation. You can go to the next slide. Self-help, real important. Certain documents say that if an owner is in violation, the association has a right of what's known as self-help. Usually these are maintenance provisions or architectural control provisions, where if an owner is in violation, the association has a right to enter the lot and perform the maintenance, or if it's an alteration, the right to enter the lot to remove the alteration. Under current appellate law, before the association can file suit, in addition to going through the pre-suit mediation, you also have to make an attempt to use a self-help remedy, because that is, you have to basically exhaust all remedies available to the association before you can actually file the lawsuit. And according to these appellate court cases, if the association has the right of a self-help remedy, it must attempt that first or do that first before it can file a lawsuit. Ta-da.
And you've
I
reached
apologize for